Hello, folks. This lecture is about writing a memorandum of law to the court. When we write a memorandum of law to the court, we are advocating a legal position. We are trying to convince a judge that our position, or what we want the court to do, is the correct legal position based on the current case law that we have researched. So as a result, our memo is a little bit different than the memo of law that we write to our boss in a law firm. Okay, because when we write to our boss in a law firm, oftentimes it's a question of feasibility. Look into this issue. Do we have a case here? Or I want to find the law on this, or I want to find the law on that. And you're just giving law. Okay, it's a more neutral thing. So that is the big difference between them. The other difference is because we are writing now for a court or a judge, our memorandum of law to the court is more formal, okay? And it follows a very specific format that I will tell you, it's very basic, okay? It's basically 3 sections. Generally, it's the first section is the facts, the second section is the argument, and the third section is the conclusion. Okay. Now, let's start with the facts. In the facts section of your memorandum of law to the court, you're just going to simply write out all of the relevant facts that are relevant to your particular legal issue, and only those facts and no other facts. Your goal in writing the facts or writing the entire memorandum is to be as brief and clear and specific as possible. Brief, clear, specific as possible. Okay, that is the goal of all legal writing. All writing actually should be that. The judge has no time to wade through irrelevant facts. So how do we know what facts to include in our facts section of our memo? Well, we know it because we have already researched the issue, or the issue has been already presented to us. Okay? We tailor the facts to what the issue is. So we need to know the issue before we write the facts, not the other way around. Okay? In the example that I gave you of the authentication of a letter, we knew what that issue was, or I knew what that issue was, because the defense attorney, whose client was incarcerated, filed a brief claiming that the letter was insufficiently authenticated at the violation hearing. That was the issue. And he presented it to me, and I responded. So that's why in the last assignment I told you we don't necessarily need to know all of the gory details of the case. In the assignment that I gave you, I told you to assume that the judge is sitting on this trial and he's already heard all of the witnesses and all of the testimony regarding what happens. And now he's faced with this question of whether or not to introduce this letter into evidence. So the only thing he needs to know is what's in the letter, what are the circumstances that it was introduced into evidence, and maybe some other relevant facts from the case, depending on what case law you found. Okay, so that's the facts section. Now, the argument section of your memo is basically simply where you apply the law to the facts to make your legal argument. In the argument section of your memo to the court, you are using the IRAC method, but you are not writing out issue, rule, argument, or analysis and conclusion. Okay? So you are going to use it as an organizational tool. What does that mean? It means generally you should start your argument section with a rule of law, or sometimes the rule of law may have other cases that explain it and explicate it and give more detail to it. So you start out by stating what the law is and the rule of law that applies to the issue that you are presenting. Okay? You do not generally need to state the issue in the argument portion of your memorandum to the court. Why is that? because generally by the time you get to that point, the parties know what the issue is and it's implicit in your argument. For example, in the um, trial hypothetical I gave you about authentication, the trial judge was confronted with this issue by defense counsel in the middle of the trial. And so the issue came up at sidebar at the trial when defense counsel raised this objection about proper authentication. And the judge then framed that issue for the attorneys and said, okay, this is the issue. This didn't say it in those words, but said, okay, I want to know about authentication. Is this admissible or not? Educate me. And that's what you're doing generally when you're writing a memo to the court, believe it or not, is you are educating the judge, because the judges don't have encyclopedic knowledge of all of the case law out there, nor does anybody that I know of. Okay? So skip the issue generally, just start with the rule in your argument section. State the rule of law, then in another paragraph, go on to apply the rule of law to your facts. And when you do that, again, you select facts that are relevant to the rule as they fit into the rule. And you select those facts and you apply the rule of law to those particular facts. So after you have completed your argument in your memorandum, you should end your argument by one sentence, which is the C in the IRAC method, your conclusion. So once you complete the argument, you should have a conclusion sentence. Oftentimes your conclusion sentence will begin with therefore, or thus, or because blah, 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 then blah, blah, blah. Okay? And like, for example, in the rule of authentication, if you are advocating that the document is admissible, your conclusion might say something like, therefore, because blah, 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 meaning the document meets all these requirements, it is admissible under the rule of authentication. That's the end of your argument, and you have concluded. So you've used the RAC portion of your IRAC in your argument. Okay? Now we move on to another conclusion, which is confusing, but there's a weird format in all motions or all memoranda to the court, at least I see it in Massachusetts, where you have a conclusion, a separate heading for conclusion in your memorandum of law, boldface, and you put one sentence in there. For the reasons herein set forth, the court should admit this document, or whatever it is you're seeking the court to do. For the reasons herein set forth, this court should dismiss the case. For the reasons herein set forth, the evidence is inadmissible, or whatever the case may be. Okay, one sentence. Lawyers confuse this all the time. They think they're using IRAC. I see it, and they have this long conclusion with 3 or 4 paragraphs. No, that's not that's not the format. And this is purely a matter of form, of Massachusetts form, and probably legal form, and I think a lot of states. But that's the way you want to do it, and you'll see. All right, so I'm now going to turn to an example that I have uploaded that you should have read by now. Thank you. Okay, so here we have the memorandum of law that I uploaded that you should have read. This is my memorandum in opposition to the defendant's motion for new trial. This defendant was convicted and incarcerated on a sex offense with a minor. He filed an appeal. His lawyer filed a brief. This is my response to his brief, or his memorandum of law, in support of his motion for new trial. As I said to you, you will look at this brief. You'll see that it has 3 major sections: facts, argument, and conclusion. Okay, let's start with the facts. Before I go any further, you should know what all this stuff is. I hope you do by now. This is a standard legal pleading format. If you don't, then we need to talk about that. Maybe we'll have a lecture about that, but you shouldn't have that. When you write a memo, your boss should have these headings and samples for you to look at. Okay, so let's start with the facts. Remember, I told you we only include the facts that are relevant to our issue that is presented. I know what the issue is in this case. I know what the issues are because defense counsel has filed a brief. He has researched the issues, and he has presented them to the court in support of his theory that the case should be overturned. So, okay. So you'll notice that my facts are divided into subheadings. This is a fairly complicated case, or a long trial, or not a long trial, but it was a trial. So There was a transcript of 300, 400 pages that had to be boiled down to these facts. Okay, so you'll notice my first heading here is under the facts says opening statements. All right. So why did I put that there? Because defense counsel in his brief had a section on opening statements, and he pointed out in his brief that the trial lawyer messed up by referring to his client's incarceration to the jury. He made an offhand comment about that. That's a no-no. As the case law says, it's a no-no. So he made a big deal of that, or tried to in his brief, saying that that was grounds for a new trial. Okay. So notice in my opening statement here, I have one paragraph. The opening statement probably took up 2 or 3 pages of transcript. It talked about the facts of the case and so forth. And you notice I did not repeat the entire opening statement, right? I didn't repeat the entire 3 pages of transcript that counsel took, in his opening statement. I repeated that which was relevant to the particular issue in this case, which was the incarceration. So you'll notice I repeated what was said by the lawyer, which was he said something like, "Oh, he's been quite upset about his incarceration." I don't know why you would say that as a lawyer, but he said that. And then there's a sidebar. Notice in my facts section, though, I go on to talk about a limiting instruction that the judge gave to the jury. Now, I think that counsel in his brief made an offhand reference to a limiting instruction. I made a big deal of it. I repeated the entire limiting instruction here verbatim. Why did I do that? Because it helps the Commonwealth's argument, which is, well, there was a mess up, but the mess up was cured by the limiting instruction. That's what the law says. A curative instruction by a judge can correct errors that are made during the trial. So that's my opening statement section, a single paragraph, and I made sure I stated facts that helped me. Okay, so that's an example of tailoring your facts to the legal issues that are presented. And then there's a section on the victim's testimony. Again, I'm just responding to defense counsel's brief. He has a section on the victim's testimony. I insert facts here that I think the counsel may have neglected to insert that make sure that the judge has an entire good picture of the facts. And that's what you're doing as counsel. You're giving the judge the facts that are helpful to your case. That doesn't mean you are allowed to eliminate facts that don't help your case. I'm not telling you to do that. You're supposed to include all of the facts, but you can emphasize facts. Like I said, counsel in this case just made an offhand reference to a curative instruction. I made sure that I blew it up by printing out the entire thing that the judge said. Okay, so you can emphasize certain facts. Okay, all right, that's enough about facts. I think we've got the facts section here going down. It's, like I said, it's a quite lengthy trial. You should know that this was a 300 or 400 page transcript, and I boiled it down to my facts, as did counsel, to just a few pages of facts. So that's what we mean by selecting important facts or relevant facts. All right. So here's your argument section. Again, I formatted my argument in response to counsel. That's what you can do if you're responding to somebody. It's easier in a sense. So I just have a section on applicable law. And in the applicable law, I state Commonwealth versus Safarin. And Safarin is a case that defines what you need to show ineffective assistance of counsel. Okay. And the appellate attorney's major argument on appeal, or I'm sorry, for his motion for a new trial, is that the trial lawyer was ineffective during the course of the trial, that he made various screw-ups, all of which together constitute ineffective assistance of counsel, to the point where his client was denied his Sixth Amendment right to counsel, to the point where his client should get a new trial because his lawyer was so bad. Okay, so we know here that so that's why I set out the rule right in the beginning here. I set out the rule on the second paragraph here, Commonwealth versus Safarin. It tells us what ineffective assistance is. Okay, and then I have some more case law talking about the rule of ineffective assistance here, and I go on. This is all law basically here in this paragraph, and then finally down here under B. I argue that defense counsel's conduct did not constitute ineffective assistance of counsel. and I go on to apply the law to the facts. If you read down, the application part occurs here. Um, I say any prejudice resulting from the attorney's failure to object in this case was eliminated by the judge's fresh complaint instruction prior to Ms. Jones's testimony, et cetera, et cetera. So then I go on with the facts. I select the facts that fit that argument. I talk about the jury instructions that the judge gave and how great they were and how they eliminated any possible prejudice, blah blah blah. So I'm applying the facts of the trial to the law. Okay. On the next paragraph, you don't necessarily need to worry about this, but here's where I distinguish some cases that the defense attorney cited. That will be something we'll be talking about, and I did that with several of the cases. The most important case I needed to distinguish was the Stuckage case, because it's the case that was most harming to my argument, and I needed to make sure that the court knew this is not a Stuckage situation here. This is not a whatever. You should get it when you read the brief. Okay. So that's the argument section. Um, Again, more subheadings responding to the defendant's argument here. And it's quite a lengthy memorandum, but that's basically, in a nutshell, again, an example of a memorandum. Again, you'll see the conclusion, again, the one sentence conclusion at the end of the memo. For the reasons herein set forth, the defendant's motion for new trial should be denied. And then you conclude it. You should have a certificate of service for all of your legal documents. You should know what a certificate of service is by now. It's simply a statement that we have served the opposing counsel with this document, the date we served it, and how we served it. First class mail, email, etc. Okay? All right, that's it. Thank you.